This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions all about family law. That's the kind way of talking about fighting amongst yourselves. Divorce, child custody, calling your questions on everything from alimony, child support, getting your visitation schedule changed. The 31 Law Call number 256-536-0077. You can also email a question. You can email a question on any legal topic any day of the week. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull out some of your email questions, and we will have some of those for you tonight. Getting started tonight, we've got Will League from Timberlake and League, and we've got Kobe Boswell from Next Step Family Law. So he's going to help answer questions about family law. Good to have you here tonight.
Thanks for coming up, Kobe.
I appreciate it.
And before we get started on family law, we wanted to show you some video. You know, it's summertime, everybody's getting out and getting active. In this case, this looks like something that could be around here local, but it's actually something from YouTube. If you get involved in something like this, you're getting pulled behind somebody's boat, and this goes awry. So, personal injury law, Will, what do you see in that?
There's several issues. I mean, it doesn't look like that was the intended purpose of the designer of the tube. But we're talking about maritime law, injuries on the lake, summertime injuries. We handle a lot of these cases, and there's many different things here. First off, if you're using the tube for its intended purpose, under the Alabama Extended Manufacturer's Liability Doctrine, if the manufacturer places an unreasonable, defective, or dangerous product into the stream of commerce, there could be a claim against the manufacturer. Now, what if they were going in excess speed? What if there was alcohol on behalf of the driver? Okay, if that rider was injured and the driver was either drunk, using excess speed for the design of that particular tube and someone is injured, he or she can be liable for injuries to that particular tuber, the rider on that tube. You know, you have to look also at assumption of the risk. Anytime you get on something, you're doing that, you assume the risk. Now, can you assume it at what age? I mean, if you're 10 years old, can you assume that risk? The law says that you're kind of incapable of negligence 8 and under, and then maybe comparative negligence above that. So you have to see who the rider is, what type of assumption of the risk, you know, how old were they able to assume that risk, and does that absolve the driver, you know, of any liability? Again, you're talking about maritime law. Any navigable waterway is under federal maritime law, which is comparative negligence, and that's different than Alabama's contributory negligence we talk about quite often. Again, the tube wasn't supposed to fly that high. It happens, but again, is that a design defect? You know, many issues come up, so go and talk with a lawyer if you have any injuries or any issues with equipment or products liability cases like that. Now, tonight, Sharon, we're talking about some of the most serious laws that we talk about, and it affects more Americans than you think. And so anytime we get in domestic relations, child custody, child support, I mean, the divorce rate is crazy high. You do domestic relations work. Kobe Boswell does work with children, divorce, child custody. And when I talk to somebody, it's good people at their worst. Yeah. And you know, you guys handle it all the time. Now, what's the difference? When I usually have a case, we try it to a jury. Right. Now, in domestic relation cases, when people are getting divorced and there's children involved, can you ask a jury, or what's the difference in that?
Kobe, take that.
You never really get a jury. You're always going to get a judge that's going to decide these types of cases. And quite honestly, you wouldn't want to put a jury in front of everybody to decide child custody issues or divide up your personal property or things like that. It wouldn't. It would probably be an ineffective use of everybody's time to do so. But you're only going to get a judge. You're going to have a judge that's going to hear both sides of the case, sometimes a third side if there's a guardian ad litem or the kid side involved, but they're going to weigh that evidence and rule based on those two sides.
You know, when I talk to some of the judges, they're some of the most difficult cases that they decide when you're talking about where's the child going to live, custody, things like that. Is it a big difference in what judge you draw and what county you're in?
You know, I think it is. I think that the more metro areas, Madison County, our judges seem to be, I think, more liberal. I think that we have more joint custody cases. The further out you get kind of more traditional families sometimes, and I think that they see things a little bit differently.
When you say traditional, you talking about leaning towards the mother for custody?
Maybe so, and probably cases where mom was more involved than dad was. If that's the way the family structure was before, then it's more likely that mom would get custody. If you come into areas where moms are working just as much as dads are working, you are, I see, more likely to get joint custody. Now, what do you think?
Let me ask you this, Kobe. Is it automatically they try and do joint custody?
It's pretty much the starting point. Our statute kind of says that's where we need to start this process and kind of move away from that. I think, kind of answering y'all's question, it depends on the person and the different judges. Everybody has their own background, and that's the one thing about family law is it's hard not to have that influence what's important to you and what's not. Each one of our judges are human beings just like the rest of us, and some things are more important to others than are not, and that's kind of what the difference is when you go between county and county and judge to judge.
And lots of them have been divorced, and lots of them have had child custody issues themselves, so their own backgrounds play into it sometimes too.
Serious stuff.
We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, hi. I just recently purchased a house at sheriff's execution sale at the courthouse. The property had been conveyed to an individual who was married but not to the wife, and that was before the sale. Anyhow, the couple apparently got divorced, and she won the right to stay in the house while he made the mortgage payments. But my question is, does she have a homestead right that I have to respect, and can I evict her or eject her from the house, or do I have to wait and have a sale for division?
Interesting. A lot of stuff going on there.
You've got a lot going on. The divorce is over. The divorce is final, right?
That's correct.
And it's just that she's allowed to stay while he makes the payments, but he's not been making the payments.
Well, he's been making the payments. It was a sheriff's sale on a judgment against him that was separate, that wasn't a part of the divorce.
Gotcha. I have not had this issue.
Isn't there a right to reclaim after a year?
Well, you can still go back and do that, certainly after the tax sale. I think the bigger issue is what the agreement says with respect to how the house was divided up, whether or not it was awarded to the wife, awarded to the husband or not. If it was awarded to the husband and she just has a right to stay in that house, then it may be something that you could force her out of that, file an eviction action. But if it's something that the house was not divided up and it had to be sold or something else and she still has a right or an interest in it, you're going to have to go through a whole separate action, an ejectment or a partition for sale and division like you discussed.
You know, something that Will was talking about before, he's talking about ages of kids and giving consent when we were looking at that video. One of our favorite questions that we get is talking about kids and ages, and at what point can the child decide where they're going to go?
Right.
What's your answer?
I always give the glib answer of 19 when they become an adult, because unfortunately, just the way our law looks at it is we're not going to let children make that ultimate decision under Alabama law. Until you become an adult, you do not get to decide that answer. But anytime in between that, our judges will take into account what they have to say, but they certainly don't let them make the final decision.
Kids do get called to court from time to time, though, right? You had mentioned the phrase guardian ad litem. So what is a guardian ad litem, and how does that figure into custody cases?
A guardian ad litem is an attorney that's appointed just to represent the best interests of children. So they're only looking out for what they believe to be in those children's best interest in a given situation. So they're not advocating for a mother, a father, a grandparent, or anybody else other than those kids. And so the court sometimes appoints them in an effort to make sure that the kid's interest is represented. A lot of times what we have in family law is parents or parties vying for custody over a child, and the child's needs and what's important to them kind of gets lost. And so they're a really useful tool, and our judges really, I think, lean on guardian ad litems in this process.
And it's a vital role, not only in the domestic cases, but in the injury cases that we have. I represent a minor. You can't resolve a claim, personal injury claim or otherwise, for a minor without a guardian ad litem coming in, evaluating the facts of the case, evaluating the injuries, evaluating the liability, and we work with the guardian ad litem to provide as much detailed information as possible, and then that case will go in front of a judge to determine whether or not the settlement is in the best interest of the child. And so guardian ad litems across the board provide a vital service to the community, and especially to minors, to not only child custody, but personal injury claims, if they're involved in DHR, the judge can order a guardian ad litem to protect the interests of those child. And then it's it's across the board. Madison County lawyers do a great job of filling that void to help the children in Madison County.
Why would a parent not make the best decision with a personal injury case? Why would they take a deal that's not best for the child?
And it's A to Z, but oftentimes when let's say we collect a significant amount of money for a child and they're a minor. Well, a 10-year-old, 15-year-old, 20-year-old, even 25-year-old. When you got that much money, sometimes there's poor decisions to be made, not only by the minor, but if you've got a parent in charge of those funds, hey, the light bill's due, things are due, tuition, things for the car, and so you want to make sure the parents don't just spend that money frivolously and not save it for the child's benefit. Oftentimes, you're going to get a conservator to administrate the funds, administrate all the things related to that. You can set up a trust and have a trustee do those things. There are many different tools to preserve that money until the child reaches the age of majority. But let's be honest, at 19, sometimes kids with that much money, and at that age, you're going to make poor decisions. So we can put structured annuities in place, things that will help this child. I mean, we've had death of parents, and a 10-year-old to administer this money for a long period of time. You want to make sure the child's got college care, and that can take care of him or her for a long period of time, other than just dumping a bunch of money on a 19-year-old.
Gotcha.
Because I've had clients call me from Vegas once they turn 19. Thank you for handling my case. And,
I'm going to live it up now.
Exactly, and so you need those tools. 19 today wasn't 19 50 years ago.
It's not. Okay, you were just mentioning college. It used to be years past, a divorce judge could order the parents in a divorce case to pay for college. What's the status these days?
It is not the case. It's a question I get all the time. I know you probably get it a lot as well. It's just not the case anymore. The way the law works is that we cannot order parents to pay for college once they reach the age of majority. We only deal with minority and kids under one special circumstance with respect to kids with disabilities. But other than that, they outlawed that many years ago now. I can't even remember how long ago it's been at this point. But at this point, it is no longer something that's on the table. You can certainly pay for your kids. Nobody's going to prevent that. You're just not going to be ordered to do so.
Do you guys see a mediation process before trial where you try and sit down and work it out? But do you see where parents will enter into an agreement that will split 50-50, 70-30, whatever it is, and then later to enforce that agreement, the judge will order someone to pay for post high school education?
Yeah, you can agree to do things that a judge couldn't order you to do. You can make up a schedule or an agreement about college or an agreement about monies that a judge would not order. But if you make that deal, you've got a contract and you've got to live up to your end of it.
Mm-hmm.
Yeah, you can pretty much agree to anything that's not illegal, and you're going to be enforced or held accountable to that. But a lot of times attorneys would be real reluctant to letting somebody enter into an agreement that a judge could not order them to do if they went to court.
Yeah. They're telling us take a break. We're going to take a break and we'll be right back answering more of your questions about divorce and child custody. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovia. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Dovia. Got with me Will League from Timberlake and League and Kobe Boswell from Next Step Family Law, and we're talking about family law tonight, divorce, child custody, and questions related to that. We've got Ann on the line with a question from Fort Payne. Hi, Ann. Thanks for calling. What's your question tonight? And we've got a busy signal there. Okay, she had a question. There we go. Ann, let's try again. Ann, thanks for calling. What's your question tonight?
My husband passed away back in March.
Yes, ma'am. Sorry.
And he had, thank you, he had some property, a house and some property that it was in his name, but not my name. So what 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 do I need to do about it?
Is there a will? Did he have a will?
No, he didn't have a will.
Okay. Did he own that property with anybody else?
No.
Okay. So as long as it's, so for example, if Sharon and I own property together and it was rights of survivorship, if I perish, it all goes to her. So if he didn't have a partner, that's good for you. If he died without a will, it would be under what's called intestate succession, means he died without a will and it goes in accordance with the law. If if you're his wife and you were married at the time of his death, then you will receive a percentage, usually an amount, and then it's split between you and the children if you guys have children. If there are no children, it goes further down the line, but it should be all coming to you if there are no children or any other claims on that particular property. So without a will, go see an estate attorney, and you want to open up an estate and have an accounting of his assets, and any estate attorney can help you do that, and ask them about intestate succession, and they'll get it set up for you, petition the probate court, and hopefully have that property transferred into your name as long as there are no other claims, no other partners on that particular property. So sit down with sit down with a lawyer who does probate, and you sort that out. Look around for a will, but if there's not one, there's still ways to go about it under the law.
And don't wait too long about that, okay? And we are
right.
sorry for your loss. Let's talk a little bit about child support. Kobe, how is child support figured out in the state of Alabama? What do you do if you don't like the number?
Well, child support is a math equation, and they changed it. They just changed it starting in June of this year again, and how it's calculated. So anytime you have attorneys doing math, you should be concerned. So we plug it into a formula and calculate the numbers based on gross income and insurance and some other things that are factored in there. As far as whether or not you don't like it or what you do if in the event that you don't like the number, your discretion is to try to resolve that prior to getting to court, because our judges are very limited when it comes to that, of what they can do to deviate from the number of what the calculation comes out to. So if you go to court and you ask a judge to do it, they're going to use the numbers, and that's what they're going to do.
Let me ask you this. Let's say there's a change in circumstances. Somebody loses a job or finances change.
Yeah.
Okay, that's option one. And let's say you agree, for example, that parent A is going to provide health insurance, for the children. Under what circumstances will the court not enforce that? Let's say they decide to drop the health insurance, or there's a change in financial circumstances.
Sure.
I mean, I think the judges understand things happen.
Yeah.
But if it's just a decision on parent A, how do you go about enforcing that, or what's the first step to addressing that issue?
So let's start off with, if somebody's got a change in the job. So if you've lost a job and you're the person that's having to pay child support, you need to go down and file for a modification, and you need to file sooner rather than later, because the new number will not be calculated and enforced until you file. So if you wait 6 months and then you file, you're going to try and come back and say, oh, back in July I lost my job, so I ought to get some credit for back then. They're not going to give you that. So as soon as it happens, go file and ask for a modification of the child support. Okay?
And then
add to that.
Now, if you're talking about whether or not somebody intentionally drops insurance when they're supposed to carry the children or something to that effect, the court's going to do a couple of different things. They can certainly hold you in contempt for violating the court order or violating the agreement that you entered into. Not to mention the concern around dropping insurance with respect to your children and what that might bring. But more than likely, the court's going to actually modify that agreement if one party asks for it, in order to put that insurance requirement on the other parent, the one who didn't drop that insurance, because that parent's kind of shown that they're not reliable. We can't count on them to cover these kids, and the court's primary concern is the best interest of the children, and not having insurance is not in the best interest.
Right.
And that insurance cost goes into the formula that you're talking about. So if we've moved it from one parent to the other side, now we've got to redo those numbers again, and the person who, if they were paying child support and they were the provider of the health insurance, that number is going to go up even higher than what it was before.
A lot of parents are wondering about costs.
Yeah.
So, okay,
Yeah.
parent B is not doing what he or she is supposed to do. We've been divorced 2 or 3 years.
Yeah.
But when you go back to your lawyer, is it similar costs? Are we talking about a mini divorce all over again, or is this a modified situation?
It can be. It depends. It depends on what you're looking for. If you're looking to retry some of these issues and get the judge to change what the order was, You're going to have witnesses all over again. You've got a lot of evidence there again. If you're just talking about recalculating child support, it doesn't have to be quite as big a deal. But what are your ideas?
Unfortunately, cost is all dependent on the other party, right?
Yeah.
It's how difficult they want to make this process. If they make it relatively easy on you, then the cost doesn't have to be that expensive. If they want to fight everything and make you try every case to its fullest extent, then it can get expensive.
Yeah.
We've got, I think it's Rich on the line from Gurley. Hi, Rich. Thanks for calling. What's your question tonight?
My question is, when you got a person out there that's got kids, and they call them mama babies or daddy's babies.
Okay.
Baby mama.
They got child support and they're not paying it. Does the state come back if they're not paying it and take their car plates, stop them from driving?
Let's talk about that.
Yeah, what's the penalty if
What
someone
can happen?
doesn't pay child support?
The Department of Human Resources has the ability to go in and they can effectuate a lot of different things that private attorneys cannot do, right? And so one of those remedies is to go in and suspend driver's license until you pay that child support. It's serious. When you turn over your rights to DHR, they have the ability to go and seize tax returns, and they can absolutely come and suspend your driver's license until you decide you're going to pay your child
Do y'all
support.
see that happen?
Some, yeah. Tax interceptions, definitely. If somebody's supposed to be paying their child support, and if it's going to Montgomery, there's a certain address that you mail it to, and if the state sees that you are behind, they will intercept your tax refund. Yes,
On the
and maybe
civil-
even somebody else that's living with you if you're doing your taxes together. Somebody
on
can
the
get it.
injury side of that, Sharon, I'll be working a case for, let's say, a minor, or for just a regular, an adult, and all of a sudden DHR will come in and say, Mr. Lee, you're about to win this case for child A or client B. Please know that he or she has not paid child support for the last 20 years, and there's a huge tax bill, and they will find out, and then they will file a lien on that particular case. So therefore, I'm working a lot of times for DHR to recover that money.
Yeah.
Now, I think the caller was talking about uninsured motorist or liability coverage. In Alabama, it's a law that you have to have liability coverage, and if you don't, the department can suspend car tags, driver's license, things like that. Now, I don't know how often it's being enforced because we see a lot of uninsured drivers, and as a firm, we're starting to write the Department of Transportation. We're starting to write the licensure department and turn these folks over because it is a law, and maybe that'll help them enforce the mandatory liability insurance in Alabama.
We're going to take a break, back answering more of your questions in just a minute. If you didn't get your questions answered tonight, here's how to get in touch with Kobe Boswell with Next Step Family Law out of Huntsville, but he goes all over North Alabama, 256-534-8799. Also check out Next Step in FamilyLaw.com. Here's how to get in touch with Will League with Timberlake & League. They're personal injury attorneys, so everything from car accidents to medical mistakes, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And Sharon Doggett, family law attorney, 539-7337, SharonFamilyLaw.com, domestic, child custody, all those sorts of issues. Both these guys know what they're doing.
Good to have Kobe with us tonight. Thank you all for all your calls and questions, and we'll see you next week.
Good night. All right, brother.